Well, good afternoon and welcome to this last in the first semester speaker series. We're delighted to have with us today Dr. Vincent Kazmierski, who's assistant professor at the Department of Law at Carleton University. He completed his bachelor's and master's in political science at McGill prior to completing his LLB at Dalhousie Law School. Thereafter, he clerked for Justice McLaughlin at the Supreme Court of Canada, as she then was, prior to her becoming Chief Justice. He worked for a period of time at a leading law firm, was called to the Ontario Bar, and then has more recently completed his SJD at the University of Toronto Faculty of Law, in which he wrote about a constitutional right to access government information. And we're going to have the chance to hear from him on some related topics today in terms of whether the Supreme Court of Canada will protect our right to access government information. And I'd like to welcome Dr. Kazmierski.
Thanks very much. Thank you to Dwight and to Barb for inviting me to speak here today. Thank you to the College of Law for hosting me. It's my pleasure to be here. First of all, it's my first trip to Saskatoon, and it's been a wonderful chance to see the town, and my first visit here to the College of Law and your new building, which is very impressive. I also wanted to say thank you to you for coming today. I know it's the end of term. Professors have marking to get to, and students have exams to prepare for, so I appreciate that you have other other things that you could be doing, and so I'm very appreciative that you made time to come and listen to me today. I also wanted to say that I really appreciate the chance to be here today because it gives me the chance to talk or try to synthesize three areas that I've been writing about for a few years. And those three areas are, number one, the role of the courts in protecting our democratic process. Number two, the importance of access to government information in that democratic process. And the third is the important role that we as citizens play in both promoting access to information and ensuring that our democratic process functions well. And so what I want to do today is to try and tie those three themes together by talking about this question of what the Supreme Court of Canada is doing to protect our right to access government information. And what I'm going to do is I'm going to look at three cases in particular that the court has released in the past few years, but I want to do that in a broader context. So I'm going to start first by telling you why I think this topic is important. I'm going to set the topic in the broader context of what the Supreme Court in particular is doing in terms of protecting our democratic process. Then I'm going to focus in for the majority of the talk on these three cases that talk about how the court is really protecting our right to access or perhaps not. And then at the end, tie it all back to this kind of overall discussion of this notion of protecting democracy and judging democracy and what the courts are doing to help in that regard. Now, if you could see down here, you'd see there's 40 slides. Now, I am not going to speak substantively about 40 slides. I use my slides as a kind of footnote to my talk. I teach legal research, so I appreciate that many students have just handed in their memos. So I'm using the slides kind of to show where I'm getting information from, and for some of them I'll kind of go into them in more depth. But what I kind of will do today is kind of be a proselytizer with PowerPoint. So I'm here to kind of give a message about the importance of access and the importance of the court's role in protecting that access, and I'm going to use my PowerPoint slides to help us get there. So my first question is, well, why is this an important topic? And the answer is fairly easy, right? Access to government information is a key, it's a cornerstone to our democratic process. Access to information gives us information that allows us to participate in the political process, and it allows us to hold our government to account. Right? If we weren't able to get information about what the government was doing, we wouldn't be able to fully participate in the process of making decisions. But more importantly, in my view, we wouldn't be able to judge what the government is doing. The Supreme Court has recognized this. information commissioners have recognized this, governments have recognized this, civil society groups have recognized this. Unfortunately, even though we recognize that this right is extremely important, it's also an underprotected right. And it's underprotected for three main reasons. One is that, and kind of the overarching reason, is that governments themselves don't really have a self-interest in promoting access to government information, right? They have an interest in guarding information. So what happens is that in many cases, you'll have politicians talking about the importance of access to information when they're in opposition, but when they get to government, their commitment to that concept dries up. Right? So you have access to information protections that have been put in place for 20 or 30 years, but there haven't been really any major improvements since then. So our existing protections are withering on the vine. They're becoming out of date. The second problem is that often those same government officials are willing to tolerate abuse of the existing protections. And then the final concern is that you, in some cases, have new governments coming in and taking away existing protections. Right? So you have three problems with our existing rights to access government information, and all of them stem from this overarching problems that governments themselves, when they operate in their own self-interest, don't necessarily want to promote this right. Okay? And perhaps this was best stated by Information Commissioner Reid in 2003 when he said, you know, governments make skeptics of information commissioners time after time, regime after regime, scandal after scandal. They promise, right? They promise that they're going to do better, and then when they come to power, they don't. And this isn't just something that existed in 2003. In 2006, when our current Conservative government was running for election, they came out with their policy platform, Stand Up for Canada, and they listed 10 things that they were going to do to improve the Access to Information Act. Right? 10 things. Since 2006, they fulfilled one. Okay, so these are the 10 things over 2 slides. I can send you the slides if you want. They didn't do any of those things except extend access to information to crown corporations, and then they imposed a lot of exceptions to what information you could get. Right? So, and I don't want to kind of, you know, jump on the bandwagon of criticizing the Conservatives, because they're only the most recent in a long line of governments that have done this, promised change and then failed to implement. But the problem is not just that we're not getting better legislative protection, is that our existing legislative protection is being undermined when it's being administered by government officials. Right? And so in 2010, the Information Commissioner released a report that suggested that the delays in the federal system were getting to the point that the actual right to information was being obliterated. Not just eroded, but obliterated by the fact that so many departments were delaying so long before they would give access to the information to which we had a right under the statutes. The final problem has been demonstrated most recently in Newfoundland and Labrador, where the government just passed new legislation that introduced amendments to their Access to Information and Privacy Act that actually took away existing access rights. So they've created new restrictions on access to cabinet documents, whereas under the old regime, you could exempt cabinet documents from access to information requests, but the Information Commissioner could then look at the documents to see if it was a proper exemption. What they've done under the new Act is they've taken them right out of the Act, so the Information Commissioner no longer supervises that exercise of discretion. Right? And they've expanded the scope of other exemptions. And some critics have claimed that some of the expansion of exemptions under the new Act or under the amendments is meant to protect resource extraction projects and energy projects from too much supervision by members of the public, right? To make it easier to hide documents about those types of projects, which should be of concern to people in provinces such as Saskatchewan. Right? So we have a fundamental right that is imperative for the proper functioning of democracy, right? That is subject to abuse, right? It's subject to atrophy because the rights are kind of withering on the vine, and it's subject in some circumstances to rescission. So why is this important? Because in order to make sure that we can kind of maintain these rights, if we can't rely on our governments, we necessarily then take the next step and we look to our courts. Okay. And the way I want to talk about this role of the courts in terms of their role in protecting access to government information is to set it into this broader topic of what have they been doing in terms of protecting the democratic process more broadly. And I want to acknowledge that I'm not by any stretch of the imagination the only person who's ever looked at these issues. There's a wide variety of academics who are doing this. Professor Carter from the college is one who has looked at this. And these academics, Manfredi and Rush, actually wrote a book called Judging Democracy, so I'm borrowing their title for the title of my talk. They all look at what the proper role of the courts should be when dealing with situations where there's threats to the democratic process that come out of legislation. And they all agree, although these academics will disagree about what the correct role of the court is and how interventionist it should be, how to characterize that, they all agree that really one of the primary tensions is that we expect that the rules of how our democracy is going to operate should be established democratically, right? That our elected representatives should be primarily involved in setting the rules. But the problem is that those same elected representatives have it in their self-interest to set the rules for their own benefit. And here, primarily, when you're in government, it's in your interest to set the election rules, for instance, to benefit your party. And we've seen a number of cases where these types of issues, not always that particular issue, have been dealt with by the Supreme Court of Canada. And I'm not going to go through these all. I just kind of set them out as examples of cases where the court has been asked to look at elements of our democratic process and whether or not those elements that have been put in place by democratically elected legislatures conform with our Constitution. Right? Whether or not they should be allowed to stand or whether they're problematic. Right? And if you look at a number of them, I won't talk about the secession reference or the Alberta Press case here, but if you look at the Electoral Boundaries Commission, which I believe Professor Carter likes to call the Carter case, in that case, the Supreme Court of Canada was asked to determine whether or not an act that required the Saskatchewan Electoral Boundaries Commission to only recognize, or not only to recognize, but to recognize a certain amount of rural seats and a certain amount of urban seats, which happened to benefit the sitting government at the time, right? Whether or not that violated Section 3 of the Charter. Right? So this was kind of one of these quintessential cases of self-interest, right, being adjudicated upon by the Supreme Court. In that case, interestingly enough, the court found that if you interpret Section 3 as being a right to effective representation, the legislation actually was not contrary to Section 3, so they allowed it to stand. In Thomson newspapers, there was a challenge to the ban on releasing polling results within 3 days of an election. And the court struck that down, saying that it was restricting too much information for individual citizens. In Figueroa, the court considered whether or not a requirement that you had to have 50 people running for election in order to qualify for official party status was contrary to Section 3 of the Charter. And the court struck that down, saying that would marginalize too many voices in the electoral debate, and so it was contrary to our right to vote. In Harper, the court considered whether or not the existing limits on spending or campaign donations was constitutional, and the court said the existing limits were constitutional, in part in order to ensure that individual citizens could have an equal voice in the debates. And finally, in Ryan, the court considered whether or not the ban on releasing electoral results from, let's say, Nova Scotia before the polls were closed in BC was contrary to the charter. And again, they found that this ban was actually constitutional because it protected the equality of information that different voters could have. So there's a variety of kind of results that come out of these cases, right? But if you look at them, the kind of overarching theme, at least that I take from them, is that the court is very ready to establish boundaries or rules of the game for our electoral process. And then, generally speaking, what it'll do is it'll defer to the government or to the legislature when it sets up particular rules within those boundaries. Right? So you see in Harper, in Ryan, in Electoral Boundaries Commission, the existing legislation is allowed to stand. So the court defers to what the legislature has decided to do. But in those cases where the court thinks that marginal voices are going to be excluded or individual citizens are not going to be able to have a meaningful participation, it's willing to enforce the Constitution or the Charter to try and make the game even. So you have a bit of an uneven approach, but one that I would suggest shows that the court tends to like to set these kind of broad boundaries and then give the government or the legislature room to maneuver within that. And what I'm going to argue when we kind of go through the rest of my talk is that although that room to maneuver is important, I think that they've gone a little bit too far, that they're becoming too deferential, particularly in reference to access to government information. And the cost for us is that governments are allowed to put in place restrictions that mean that the restrictions or the court's approach to the restrictions the government's approach to the restrictions don't have to be justified. So we essentially get restrictions on our process, right, that aren't being justified, right, in a way that allows us to ensure that our process is working effectively. So how am I going to kind of now move on to that if we're talking about access to government information? Well, I want to do that by talking about these three cases. And the three cases in particular are the Criminal Lawyers Association case in 2010, what's known as the Prime Minister Agendas case in 2011, and then Merck Frost in 2012. I'm going to spend most of my time talking about the Criminal Lawyers Association case, right? And these cases kind of range over three areas of protection: constitutional interpretation, statutory interpretation, and the review of administrative discretion. Okay. Criminal lawyers case. This is the most important case I'm going to talk to you about today. I'm going to spend the most time talking about it. What happened in the criminal lawyers case is you had two men who were accused of committing a gangland murder. They were convicted in their first trial, and then they were granted a second trial based on new evidence that hadn't been made available to them in their first trial. And the second trial judge actually eventually awarded a stay of proceedings against the two accused. He awarded a stay of proceeding against the accused on the basis of what he had called many instances of abusive conduct, right, including deliberate non-disclosure and deliberate editing of useful information. So he accused both the police and the Crown, this is a judge, accused both the police and the Crown of deliberately withholding information from the defense. Gave a stay of proceedings, right? The two men are released, and then the OPP conducts an investigation to see whether or not the Crown and the police should be charged for this abusive conduct. The OPP conducts an investigation and concludes that the behavior of the Crown and of the police is not sufficient to warrant charges and exonerates them. And it exonerates them in a press conference without any explanation of how it reached its conclusions. And so the Criminal Lawyers Association, which represents criminal defense lawyers, was concerned. Right? They're concerned that a judge can say there's abusive conduct, deliberate refusal to disclose, and the police conclude that there's not sufficient evidence to charge. So what they did is they requested access to three documents, but primarily a major report created during the process of this investigation. And they requested it from the Ministry of the Solicitor General, which was, by the time the case was heard at the Supreme Court, Public Safety and Security Ontario. And the minister refused to give them access to the documents, claiming that they could exempt disclosure on 3 grounds. An exclusion based on criminal investigation documents, an exclusion based on solicitor-client privilege, and privacy. And the tricky part of this case is that in Ontario, there's a part of the Act that is a public interest override that says, for certain provisions of the Act, if you claim an exemption as the minister, if there's proven to be a public interest in disclosure of the information that overrides the interest in the exemption, you have to release the document. And so the Information Commissioner in Ontario, when he looked at this case, well, at the time it was the Assistant Commissioner, determined that the public interest in disclosure was sufficient to override the privacy exemption. And so he said, well, if this was just about the privacy exemption, you have to disclose. But the problem is that that public interest override doesn't apply to the exemptions for criminal investigations or law enforcement investigations or for solicitor-client privilege. So the Criminal Lawyers Association made an argument, ultimately making it up to the Supreme Court of Canada, that the failure to include those 2 provisions under this override essentially violated the right to freedom of expression because it limited their access to government information. So it's a bit of a complicated argument. It's not an ideal case for the court to kind of consider this issue, but it went up the ladder and it made it to the Supreme Court of Canada. And to be fair to the court, it's an extremely important decision because for the first time in the history of the court, it recognized in a majority decision that there is some constitutional protection for the right to access government information found in the Charter under Section 2B. Okay? So that there is some protection there. But what it did was it set so many preconditions to the exercise of that right that essentially it has restricted the ability to rely on that right to such an extent that in some ways it's I don't want to say it's meaningless, but it's a very difficult right to access. And so what I'm going to talk about for a few minutes here is the way in which the court went about its analysis and to critique the fact that they set up all of these preconditions in a way that both undermines their approach to Section 2B and essentially restricts the ability of citizens to rely on Section 2B to access government information in a way that I think really undermines the protection of the right that could have been there in this decision. Okay? Now, I want to kind of emphasize that the court at a couple of different times says we're being very clear that freedom of expression protects expression, not access. Access is a derivative right? So you only get access to information if it's necessary for you to exercise your right to freedom of expression. And they do this in part in order to make sure that you can't claim a right to access all information. And I don't have a problem with that. I don't think we should have a constitutional right to access all information, regardless of justification. My problem is with the way that the court actually established these preconditions and the way that they front-loaded all of the analysis into Section 2B. And in the end, what that means is the government doesn't have to justify the exemptions that it puts in place for access to government information because the court just excludes them from the Section 2B analysis. How do they do this? Well, I think part of the way or part of the reason this happens is linked to 2 things the court didn't want to talk about in their decision. And in order to talk about this, I need to kind of set a little bit of the context. And that is that this case, when it came before the court and you sat in the courtroom and you listened to the arguments, you could see very clearly that the court was divided. The final decision was a decision of the court authored by McLaughlin and Abella, so they came out as a unanimous decision. But the panel itself, when they asked their questions, was divided. And they were divided it seemed to me along two lines. One was a fear that if you didn't recognize a constitutional right to access government information, what that would mean is that any government could take all existing protection of access to information and remove them, and there would be no recourse. So the federal government, if you don't have a constitutional right, because our right to access is rooted in legislation, they could remove that act and we'd be left with nothing. And I think a number of the judges on the Supreme Court thought that that didn't mesh with their conception of a democratic government and a constitution that is meant to protect democracy. On the other hand, there were a number of judges that were extremely concerned, it seemed to me, by the fact that if you put in place a constitutional protection, all of a sudden, governments would have to justify all of their existing legislation, because every single provision in that legislation would trigger Section 2B, and then you'd have all these cases going up to the court that would have to go to a Section 1 analysis. So you have this tension that existed, and the court didn't decide this case for 18 months. So 3 times the general amount of time it takes to decide a case. And I think the way they got to a decision that they could all agree on is by avoiding talking about these two things. One is that, in fact, when our charter was drafted, the committee that kind of considered the charter actually considered adding a provision to protect access to information, and they voted it down. Okay, so that it was actually considered as part of the original debates, and it was voted down. So, that's fairly important. The court doesn't talk about that. The second is that there had developed, prior to this case, a line of cases dealing with how you recognize positive obligations under Section 2 of the Charter, right? Because essentially, when you're asking for information, you're not really expressing yourself. You're asking for something that you need in order to be able to express yourself. So if you're saying you must have access to information, you're realistically seeking to impose a positive obligation on the government. So in front of the Supreme Court, a lot of the parties talked about this line of cases that ran through Dunmore and Baer that set up this test, right, to kind of construct how you could trigger a positive obligation. Okay? So you have these two, I'll skip that. You have these two questions. So as I mentioned, the first one, the fact that a right was considered when they were drafting the charter, they decided not to. Court said nothing about that. Right? The dissent in the Court of Appeal built itself around that. Court said nothing. The parties argued about it. Court said nothing. On the issue of the positive obligation, right, and whether or not to use this Dunmore-Baer test, the court shrugged its shoulders and said, well, we gain nothing further by this debate. Rather, it's our view that the question of access to government information is best approached by building on the methodology set in Irwin-Toy Limited. Now, those of you who study Section 15 will recognize this as the back to the future move, right? You don't like what's going on in Section 15, go back to Andrews, right? And rebuild. Right? You don't like what's happening in Section 2, go back to Irwin-Toy. And my contention is that by doing this, by avoiding these two questions and going back to Irwin-Toy, essentially what the court did was create a hybrid approach, but a hybrid approach that ultimately treated requests for access to information as a lesser form of expression. A lesser form of expression that they were allowed to put added restrictions on. So, the hybrid approach, they go back to Irwin-Toy and they say, okay, we're going to reframe the original questions in Irwin-Toy. So the original questions is, does the activity have expressive content? Second, is there something that excludes protection? This is the method or location issue. And then finally, is there an actual infringement? So, how do they mess this up? Let me get caught up with myself. The first way they mess it up is by this notion of treating access to information as expressive content without dealing with the notion of this positive obligation. And in essence, what they do, because they're not willing to deal with the positive obligation thing, is they create a proxy. I almost said pox. They create a proxy, a proxy, all right? And essentially they say, in order for it to be meaningful, in order to be expressive, it must be necessary for meaningful commentary. No other form of expression under Section 2B requires the designation that it's meaningful before it receives Section 2B protection. Corporate speech doesn't have to be meaningful to get Section 2B's protection. Hate speech doesn't have to be meaningful. Child pornography doesn't have to be meaningful to be protected under Section 2B. Right? The value of the speech is considered under Section 1, but to get Section 2B protection, all it has to be is an expression of meaning. So what happens here is that the court says, we're going to create this precondition. It has to be necessary for meaningful commentary. Okay? An added hurdle. And what that means in this case is that the court is able to say, well, you know, Criminal Lawyers Association, you have all this information from the judge's decision. All this information from the judge's decision, so you can comment as much as you want about whether or not there was abusive conduct. You are able to make meaningful commentary. So Section 2B doesn't get triggered. The problem with this, is that the court is able to shape, right, to tell us what they think the Criminal Lawyers Association wanted the information for, because they're able to shape what meaningful commentary is about. But the reality is the Criminal Lawyers Association didn't want to talk about whether or not there was abusive conduct in the first place. They were concerned about the OPP investigation that was able to find there wasn't any. They wanted to comment on what happened when the OPP looked at it and what the OPP did. So this kind of precondition of being necessary for meaningful commentary essentially creates a discretion in the court to shape the issue to exclude it from Section 2B. Extremely problematic from my perspective. Second element of this, and this one is even more problematic. In the second part of the test, the court says, okay, let's assume it's meaningful commentary. We can still exclude something from Section 2B protection if something about the method or location means that it shouldn't be protected under Section 2B. So this should be fairly recognizable. The method exception is primarily, the one that comes to mind most readily is violence, right? You can't protect violence as expression under Section 2B because the method of the expression does not fall under the ambit of Section 2B, right? The location one refers to, an example would be you can't use Section 2B to protect your right to go into the cabinet meetings to talk directly to the members of cabinet, right? Because that location of expression is not expressly covered under Section 2B. And the general kind of reason that location protection is put in place is this notion that some places that are under government control need to be private in order for the people there to be able to do their jobs properly. Right? You can't have people coming in and insisting on talking in cabinet meetings, even though it makes their expression more effective, being able to talk directly to the Prime Minister and the ministers, right? But you can't allow that to happen or else cabinet could never function. The problem with this approach is that it transposes in the Section 2B with access to information realm, it transposes location with types of information. So what the court says is, under location, what we are able to do is say that certain types of documents will not be subject to Section 2B protection if they're already protected by privilege or if they, releasing them would interfere with the proper functioning of the government institution in question. Well, in essence, what that means is the government is saying, not that you can't speak in certain places, is that you can't have certain types of documents to talk about. What that is a substantive restriction on expression. Right? Because if what you want is a government document, in order to comment on the document, if they say you can't have that type of document because it interferes with government, they're saying you can't talk about that. Not you can't talk about it in this location. And again, there are not other substantive restrictions on types of expression at the Section 2B stage of analysis under the existing jurisprudence. Right? So again, you have a substantive limitation on what we're allowed to talk about put in place at Section 2B rather than assessing that issue at the Section 1 stage of analysis. So I'll have to skip this, but just shortly, right? The problem with their privileges argument is they say one of the types of information we're going to prevent from being covered under Section 2B is things that are covered by existing privileges. In the same paragraph, they say, oh, we know that these are subject to the Charter, but in most cases they'll pass the full Charter analysis. So for these cases, we won't have to go through the full Charter analysis. Okay, well, we can talk about that in the question. In the location part of it, in the second part where they're talking about the impact of the government document on the functioning of government, they come back to this notion of the privacy, right? We protect certain access to certain types of documents based on the necessity of privacy. Here what they're doing, I think, is they're confusing privacy with secrecy. Right? Privacy in this context, not in all contexts, but in this context, is trying to keep a certain location free of interference to allow people the space they need to do their job. Right? Secrecy is keeping certain information from people in order to prevent them effectively from talking about it. So ultimately, what these three stages do is, by putting these preconditions at the Section 2B stage, right, make it exceptionally difficult for people who want access to information to trigger this right. And they do it in a way that undermines the existing Section 2B jurisprudence, but more importantly, means that existing rights to access don't have to be justified, right? Or existing exemptions to rights to access never have to be justified because they all get excluded at the Section 2B stage of analysis. And in my view, that undermines, right, the effectiveness of our democratic process. If we think back to the importance of access to that process, I don't have a problem with ultimately there being restrictions on our access. I want them to be justified. Right? I want there to have to be some kind of rationalized set of arguments that uphold those restrictions. And what this decision has done is created a right to some protection of access, but done it in a way where ultimately most restrictions don't have to be justified. Okay. So that's the most important thing, this constitutional right that, you know, is good because it wasn't there before, right? But in a way, right, so it sets this broad rule of the game in terms of protecting the democratic process, but it leaves so much room for deference to the legislature that in some ways it's not that useful. The two cases that I just want to touch on briefly in terms of statutory interpretation aren't as important in my mind, but I want to touch on them because they kind of reflect a similar type of approach. And I won't kind of get into the details of what happened in the cases. I just want to go directly to the decisions. Right? So in the Prime Minister's Agendas case, the important thing for you to recognize is this was a case where opposition staffers wanted to get access to the Prime Minister's agendas. And the agendas were held in a number of ministers' offices, including the Prime Minister's office. So one of the arguments was, well, is the Prime Minister's office a government institution so that it falls under the scope of the Access to Information Act? And so Justice Sharon, in kind of figuring out whether or not to give access to these documents, had to define what a government institution is and whether or not a Prime Minister's office fit within it. And ultimately, I don't have a problem with the conclusion she reached. I find her judgment was fine in a number of important ways. It is not problematic. What I have a problem with is that as part of her analysis, when she was looking at what the purpose of the legislation is, she did what I call putting the emphasis on the wrong syllable. Right? So the purpose of the Access to Information Act is pretty clear. And without reading it word for word, it's to promote access to government information. Right? Then the important part is to note that
necessary exceptions to the right of access should be limited and specific. Right? So a broad right with necessary exceptions that are limited and specific, and then this notion that there should be review of any decisions about access by an independent body. Okay? But the key is that the general accepted process is that when you're looking at exceptions, you construe them narrowly. Well, Justice Charon, in the process of her decision, looked at that wording and came out with this surprising way of reading. She says, the statute expressly recognizes that information in the hands of government institutions should be available to the public, but the right to access is subject to necessary exceptions. Okay? And so what she's doing here, and it's not, I promise you, this is not just me being dramatic about it, is she's putting the emphasis on the fact that, what the legislature did here was say, well, these exceptions are very important. They're necessary. Right? And so what happens is when she gets to reading them, she says, okay, let's look at what the exceptions are. And she says, it's important to recall that Parliament's statement of purpose recognizes that exceptions to public accessibility are necessary, and then looks at them. What that is a door for her to step through to try and expand the scope of that exemption, because it's necessary. So we should be, looking at it and taking into account all the reasons why the exception is necessary. This comes into more precise relief if you look at other decisions where other judges have described what that section says. Right? So Justice Bronskill of the federal court in a case last year said, went through it, and then he says, Section 2 of the Act also requires that the exemptions to the right of access should be limited and specific. This limited scope of the exemptions provided in the Act is essential. Right? So what Justice Noel does in Bronskill, compared to what Justice Charon did in the Prime Minister's Agenda's case, right, is he emphasizes this notion that those exceptions are to be limited. Whereas what Justice Charon did is say, well, these exceptions are necessary. Right? So let's look at them more carefully. Now, is this going to have a major impact? I don't know. Right? Is this as big a problem as I suggest? I don't know. But when you put it together with the approach that the court took in terms of the definition of the constitutional right to access, what I suggest is that it demonstrates, again, a tendency of the court to be exceptionally deferential to the notion that we have to protect the functioning of the government institutions, I think to the detriment of the right to access, right? That it's a privileging of this necessary functioning of the government institutions. Okay. Why did I want to talk about the next case, Merck? Because in Merck, Justice Cromwell, who taught me evidence, and so I think I was usually almost always right, did what I think should be done when looking at exemptions. And so in Merck, they're looking at a case dealing with third-party disclosure of third-party information. Right? And so he's looking at different definitions of what you should do to protect trade secrets and what the government should do. And when looking at the argument about how to interpret that, he specifically goes in and says, when I'm looking at the definition of trade secrets, I'm going to take into account an approach that accords with the principle that exceptions to the right of access should be limited and specific. Right? So thank you, Justice Cromwell. You've reinvigorated my faith in the Supreme Court's interpretation of access legislation. The important thing to note here is that this case didn't deal with a situation where somebody was asking for government information. Right? They're asking for information controlled from a third party that the government controls. So a cynic might argue that the court is more ready to protect the right to access and to limit the scope of exceptions when the functioning of its own institutions isn't at risk. A cynic would argue that. Mm-hmm. Okay, so that's why I wanted to talk about legislative interpretation, right? Just this notion that we're not sure how the court is going in terms of interpreting our existing legislative framework. Last thing I want to talk about, and I'll talk about it very quickly. Administrative discretion. Right? Administrative discretion actually might be the most important area of access to government information, because all of our requests for access get administered by public officials. Right? They are on the ground considering the requests, implementing them, and then making decisions about whether to release or not. And the interesting thing about the Criminal Lawyers Association case is that although it's really important for the constitutional aspect, right, the remedy came as a result of administrative law in that case. Because in the case, what the court decided was that when you read the sections of access to information legislation that grant a discretion about whether or not to disclose information. Right? So access legislation has several different types of provisions. Some of them require that the government not give you the information. Others allow the government official to maybe give you the information if they believe that that they should. Right? And so what the court said is under these discretionary provisions, the public official must not only just take into consideration the arguments against disclosing the information, but they have to consider the argument for disclosing the information. They must consider the public interest in disclosure of the information. What that effectively means is that every discretionary provision in access to information legislation has a public interest component. So this is a really important thing for the court to clarify. And the court not only kind of said that, they sent the decision back to the commissioner in Ontario because they found that the commissioner in Ontario had failed to consider whether the minister had looked into whether there was a public interest in disclosing the information that they decided not to disclose because of the law enforcement restriction and the solicitor-client restriction. And part of what the court said is, look, when the minister made their decision, they excluded all of the information. They didn't give one page out of 218 pages. Not one line was disclosed. So that to us signals that maybe they didn't consider whether there was a public interest in disclosure. And not only that, they didn't give any reasons for not disclosing. So that signals to us that maybe they didn't consider whether or not there was a public interest in disclosure. So, Information and Privacy Commissioner, please reconsider whether or not the minister exercised their discretion correctly. What this means is that the court has given us a signal that in terms of these discretionary exemptions, it's going to start to look more closely at them, and it's going to start to require government officials to make sure that they're considering not just why they don't want to give us the information, but rather why they should give us the information as well, and then make a decision. Okay, so I've blabbered along over my time. Bringing it back to where we started. What have the courts done? They've set these boundaries, right? In access to government information, as in the broader context, the court has kind of said there is some kind of constitutional protection for access, so you can't just get rid of everything. But in the way they set up that Section 2B case, or test, essentially they've given this huge scope of deference to the decisions that legislatures make about how they're going to exempt information. Right? So they're setting up this kind of zone of deference, but we see that there's still a willingness of the court to enforce some protections in certain instances. In the access to information realm, it seems to be at the ground level where you have an existing legislative set of rules and the people who are administering them are not complying, right? They're not taking into consideration the proper procedures, right? That to me matches what happens kind of more broadly, that where there's a particular interest that can be identified, the court is going to be more active. And so you see a kind of mapping of their approach, at least in my view, to the broader protection of the democratic process in this realm of access to information. Is it satisfactory? Not entirely. Right? It's kind of like my son's report card. Comes in and I say, this was pretty good, but I think you can do better. Right? And I think that the Supreme Court can do better. I think we as citizens, have to be concerned when the court gives too much deference to the people who are setting the rules that govern themselves. Right? And my concern in the access to information realm is that by giving that much deference, they're allowing the establishment of restrictions without any requirement of justification. Right? So, to kind of wrap everything up then, yes, right, we have to be concerned about protecting the democratic process. We can't rely on the government to do it all the time. We can't even be certain that the judges are going to do it all the time. What that means for us is that we as citizens have to be involved in that process. In the access to information realm, that means that we as citizens have to educate ourselves about what are your rights, what are our rights to get the information the government has, to actually then exercise those rights and to ask for information that we're not receiving, and finally to voice our displeasure when we find the existing protections that to be wanting. Right? With that in mind, I note that the Information Commissioner of Canada is currently holding consultations, public consultations, about the access to information regime. So if you have a concern, you can write to her and say, I'm concerned about the existing protections. Ultimately, we can't just rely on judges to protect democracy. We certainly can't always rely on legislatures to protect democracy. We have to take on that task ourselves. Thanks.